And we go directly on to the third section, which is general. In other words, issues spanning both of the first two sections and other issues relevant to the medico-legal sphere, and specifically focusing on recommendations. I call on Judge Niels Claassen. Judge Claassen is a retired judge of the High Court of South Africa. He is an arbitrator, a mediator, and he is chairperson of the South African Medico-Legal Association. Judge Claassen is going to address the topic of sidelining of available expertise and goodwill. Welcome, Judge.
Mr. President, guests, thank you very much for this opportunity. The Tuma Mina call by the President has in fact been adhered to long before he issued the call by a lot of private practitioners, especially the South African Medico-Legal Association, where we've been trying to assist in seeking solutions to the medico-legal crisis which is threatening South Africa at the moment. We have done various things to assist where we feel that the government and state authorities have sidelined our suggestions. Let me give you a few examples. SAMLA has prepared a protocol and offered the Gauteng Department of Health to mediate 15 of its pending cases free of charge to indicate the relevance and the success of mediation to prevent court cases. Everything was done. We were given a letter of authority, and then we asked for somebody to obtain the settlement authority on behalf of the department, whereupon we were told they could give no one settlement authority. Now, if you don't have settlement authority, you can't mediate. So that whole project, pilot project, was then moved to Mpumalanga. In Mpumalanga, we have already mediated successfully, free of charge, 7 mediations, which otherwise would have cost the provincial authority thousands of rands in legal costs, time and trauma. But it's a sad thing that it's not being done all over the country. The next item is the panel discussion that was initiated by the Chief Executive Officer of Gauteng Department of Health. And in this panel, I served for more than a year, making various suggestions as to how to limit the amount of medical negligence occurring in state hospitals. We inspected hospitals. We saw the deteriorated state in which the hospitals were. We advised how that could be remedied. We gave advice on how repercussions should take place when there's care below the standard of medical care and nursing. But nothing of that came. It became a talk show, and with the result that I had to resign because of all the efforts and suggestions being disregarded. Then thirdly, the Minister of Health, Dr. Aaron Motsoaledi, started a task team that went through the entire country, visiting all 9 provinces, with a declaration that we had drafted with ideas of how to improve the care in the state hospitals. At each of the 9 provinces, this declaration was dealt with in great detail to all the chief executive officers and the senior individuals in state hospital employment, but with very little result. It is as if the suggestions that are made to improve the health care are not being implemented. And that is a pity, Mr. President, that what we are trying to suggest is not taken very serious by the state authorities. And for that, we need your help. Thank you.
Thank you very much, Judge. The next speaker is Dr. Henry Laram. Dr. Laram is an attorney, a legal academic. He is a lecturer for the LEAD program of the Law Society of South Africa. He is a mediator, and he's the Deputy Chairperson Legal of the South African Medico Legal Association, and also the Eastern Cape Chairperson of the Medico Legal Association. Dr. Laram has done considerable volumes of work, particularly in relation to submissions to the Law Reform Commission on behalf of SAMLA, and in the preparation of a code of conduct for medico legal practice. Dr. Laram will address us on those topics.
His Excellency, the President of South Africa, Mr. Ramaphosa, Chairperson, ladies and gentlemen, comrades. There is an idiom that reads, "The devil is in the detail." I will heed that call today and not go into the detail, but rather concentrate on the head notes of submissions that we made to the Law Reform Commission. I shall commence with how I feel things could improve in South Africa, especially in the hospitals, namely to introduce, alternatively, improve risk management systems at the workplace in the hospitals. Here, we suggest complaints registers, improving note-keeping, file-keeping in a form of electronic form, preservation of these files, a better communication system between patients and the healthcare providers, patients to understand consent forms, etc. As far as staff is concerned, improve on staff-patient ratios, including supervision of junior staff, hold staff to account for failure to adhere to procedures and protocols, improve on service delivery through mentorship and training, and then take disciplinary action where necessary. Introduce a system of peer review. I'm not going to go into detail here, but I believe that it will help and enhance quicker settlements, exonerate doctors or physicians where they are vindicated, and also it serves to curve or serves to rather help other doctors or physicians through the experiences of their peers. Introducing the practice of certification where only meritorious actions and defences will be presented to the courts. Recommending mediation, some of the speakers have already touched on it. I shall just highlight the following. I believe the time is ripe where lawyers start looking at the needs of the patients instead of a right-based litigation, which we are used to and which has become part of our DNA. We must get rid of that DNA. Introducing specialist medical courts, alternatively also introducing expert assessors to assist judges and magistrates where they do not have the necessary competency levels or the expertise. An area which I believe that we should focus on is fostering a better relationship between the provincial health department and state attorneys' offices. A specialist unit needs to be established in the health departments, which has a lot of advantages as enumerated in this slide presentation. Specialist courts I have touched on. Improve the efficiency of case flow management meetings. Judges must get more actively involved. extend the prescription period to by another 2 years to 5 years. And also, as far as the notices are concerned, in terms of the intention to institute legal proceedings against organs of state, I believe that should be abolished. Contingency fee arrangement, this is a very contentious issue, but I believe that it should be lowered to perhaps 12.5%. Lump sum payments, instead of lump sum payments, look at periodical payments. And what's important further is the establishment of an independent quality assurance unit. Once claims have been settled or so, let auditors go in there and check for any irregularities and take corrective action. And then lastly, introducing a code of conduct for medical legal practitioners, and you will see what the advantages are and what the code should strive for. And I'll just repeat that if I may, Chair. Prevent unethical practices, promote ethical responsibility, very important, promote and oversee accountability, and promote and ensure service excellence that is achieved. Thank you.
Thank you very much. Thank you, Dr. Laram. What Dr. Laram had to say, and also his very detailed written submissions, feed into what is going to be the culmination of today's event, which will be the need and the methods of establishing an independent regulatory authority that properly regulates and oversees the industry. The next speaker is Ms. Ronelle van Zyl. She is a researcher at the South African Law Reform Commission. She is the person who has received Dr. Laram's recommendations on behalf of SAMLA, which go to the issue paper 33 on medico-legal claims. Ms. van Zyl will talk about the Law Reform Commission and particularly the imperative for implementation of plans. Ronelle.
The Honourable Mr. President and other delegates present here. I just want to highlight how important it is that recommendations that are made are eventually implemented, because that's something that I've found in my research, that we tend to do the same things over and over and again, and eventually there's no proper implementation and there's no monitoring and evaluation that takes place at the end of the day, and a number of speakers has already also mentioned that. What I found, for example, was that there was in 2009, under the auspice of Ms. Barbara Hogan, the then Minister of Health, a total of 10 integrated support teams established that did 10 reports, 9 reports on the provinces, another consolidated report. They made various recommendations on things such as finance, on human resources, service delivery, leadership, governance, and service delivery, medical products, laboratory, technology, infrastructure. They made recommendations. I cannot really find anything that suggested how and in what manner these recommendations were implemented. In 2012, the Minister Aaron Motsoaledi, then the Minister of Health, appointed a task team again. They produced a National Litigation Strategy report, which looked at pending medico-legal claims against provincial departments of health. They made comprehensive recommendations, again, no proper records of how it was implemented. Then in September 2013, there was a discussion document which was prepared for the Medico-Legal Summit, which was initially scheduled for September 2013, but eventually took place in March 2015. The Steve Biko Centre for Bioethics made several recommendations. Again, they mostly supported the National Litigation Strategy Support of 2012, which was to be discussed at the Medico-Legal Summit. And then following the Medico-Legal Summit, another task team was established in March 2015. I served on it and Judge Claassen also served on it. Subsequent to that process, there was a declaration released by the Minister in March 2016. The declaration made recommendations on patient safety administration and legal issues, and also proposed options to reduce claims. Judge Claassen referred to the process of visiting all the provinces to explain to the provinces all these issues and make recommendations on implementation. I'm not sure the process of implementing this. There was another report in May 2017, the Health Ministerial Task Team Hospital Mismanagement and Poor Service Deliver Closure Report, and it was presented to the Portfolio Committee in Parliament. Their 5-member task team was appointed to undertake visits to identified hospitals to investigate the state of affairs there with regard to allegations of unacceptable conditions and incompetent management, lack of service delivery, poor quality of care. Recommendations followed. We don't know how it was implemented. In the issue paper, the Law Reform Commission's issue paper 33 of July 2017, there was also a chapter on short-term solutions that was taken from much of these formerly mentioned information. The comments that I received to the paper mostly supported these and made additional recommendations, very often repeating things that were stated previously. And then there was lastly a private initiative which was confronting the right to ethical and accountable quality healthcare in South Africa of December 2018, again repeating most of this. So the lack of implementation is a concern, and also statistics, because you cannot plan if you don't have the statistics to support what you want to do. Thank you.
Thank you very much. Mr. President, the one word that should have been included in the golden threads, which Ms. van Zyl has referred to, is implementation. So we want to revise our agenda to include the word implementation as a golden thread concept. I then call again on Judge Niels Claassen to address the meeting on the topic of mediation versus litigation for medical conflicts.
Mr. President, one of the biggest problems we have is the great costs involved in litigation. And we have seen that there is a solution that is feasible to reduce that cost and the time involved in litigation. As you know, medical, legal litigation can sometimes run into 3, 4, 5 years of litigation and waiting time for courts, for judges to be available. Then there might be a delay in the judgment. Then there might be an appeal and a further appeal. So the time of litigation makes it too time-consuming. It's also too costly for the average man. We have now seen worldwide that mediation is being utilized all over the world to curtail the time-consuming and cost negative effects of litigation. And mediation works actually very easy. It's a voluntary process, so that if both parties agree to submit their dispute to a mediator, the mediator is trained. That's why there are at least 2 institutions in South Africa, one here in Joburg, one in Cape Town, that train people, especially lawyers and others, medical doctors, even pastors, to become mediators, to have the skill to assist the parties to come to a point where their needs are expressed. And that's the big difference between mediation and litigation. In litigation and arbitration, for that matter, what is of concern is what your rights are, who's right and who's wrong. Mediation is not necessarily who's right or who's wrong, but what are the real needs of the parties? Very often we find in mediation solutions that would never be able to be obtained in court procedure, but because of the access and the emphasis on establishing the needs of people, the solution is sometimes just to find somebody a job, without even paying any compensation to give them a sustainable income or other kinds of solutions that would not normally be found in court litigation. And therefore, mediation is becoming more and more popular. More people are being trained as such, and then also the Rules Board has now instituted a draft rule, Rule 41A, which will now introduce mediation into court procedure as an obligatory first step. And that does not deny a person's constitutional right to have your case eventually heard by a court of law. It just delays that right for first seeing whether mediation is a quicker and a cheaper solution to the problem to establish the real needs of the people. Thank you.
Thank you very much, Judge Claassen. Our next speaker, Advocate Reshma Athmaram, is an advocate at the Durban Bar and at the Johannesburg Bar. She is the KZN chairperson and director of the South African Medico Legal Association, and also very much involved in a recently established KZN Mediators Group. Advocate Athmaram, unfortunately, is not here today because of a family crisis, so we express our condolences to her in that regard. Her topic was to talk about mediation and specifically the High Court Rule 41A. So I'm going to tell you in less than 3 minutes what she was going to say. The South African Medico Legal Association and the KZN Mediators Group very much welcome and support the introduction of the High Court Rule 41A. There are certain technical difficulties in the way the draft was written. Judge Claassen and myself have made recommendations to the High Court Rules Board. We have visited them and they were very much interested in particularly what Judge Claassen had to say. So SAMLA is contributing to a smoother implementation of that rule, and we very much look forward to the introduction of that rule. I then go on to our next speaker, Mr. Toby van Niekerk. Mr. van Niekerk is a strange animal. He's a personal injury attorney, but he has a heart. He is going to talk to us about CP care centres of excellence and a medical aid for children with cerebral palsy.
Good morning. Stats based on the census of 2011 confirm the following. There are approximately 3,000 births every single day. 1 out of every 100 children are diagnosed with CP or cerebral palsy. Up to approximately 50% of these cases are preventable. And if you do the maths, it means that every single day, 15 children are born with the possibility of that birth and surrounding circumstances ending up in court. These matters are extremely expensive and the awards are very high, 10 million to 30 million, and it can even be higher depending on the life expectancy of the child. So do the math. The Constitution safeguards the rights of children, but it also gives access to medical care to everybody. The problem is very simple. The more you pay for the one, the more you compromise the other one. Another problem with CP matters is what happens with those funds once the child passed away. In terms of interstate succession, that money or that funds goes to the parents and the siblings. It's lost to the state. The solution is multifaceted. You've heard people saying we need training, or like Herman says, upstream prevention. You need speedy access to specialized courts. You need the establishment of centers of excellence and rehabilitation. And then also you need to curb drain state coffers. Now the proposition is to have a medical aid funded by the state for those children whose matters where negligence and liability and causality has been established to become members of that medical aid. That medical aid will then address all future medical expenses and rehabilitation. Once the child passes away, the membership stops. It's an effective system, I believe. It will shorten the period of litigation. There's no lump sum benefit, lump sum awards paid that goes to the parents. There will be a follow-up just now, and then I'll deal with it further. Thank you.
Thank you very much, Mr. van der Kerk. I can tell you that the concepts Mr. van der Kerk has spoken about, particularly the Centre of Excellence for Care of Cerebral Palsy Children, and also the concept of a medical aid for the medical specialist needs, have already been implemented on a smallish scale by private indemnifiers in South Africa, and they are very satisfied with the way it works. So there is a model, there are experts in that field, and some of them are here today. The next speaker is Ms. Alison Crosby. She is an occupational therapist, an expert witness, a case manager, and she is here also to talk about Centres of Excellence for Cerebral Palsy Care and particularly case management. Alison?
Good morning, all. Effective case management has increasingly become recognized within the medical legal industry worldwide in playing a critical, important, pivotal role in addressing the varied, multi-needs of complex cases and ensuring that the allocated funds, both pre- and post-settlement, are used cost-effectively for the purpose for which they were intended. Broadly speaking, case managers appointed in medical legal matters are essentially responsible for the monitoring and coordinating of medical and rehabilitation services and identifying and addressing any environmental and personal barriers that may be hampering the individual's ability to perform at an optimal level. In the process of achieving these objectives, the case manager plays a pivotal role in communicating with all role players, including the legal parties, representatives of the family members, caregivers, funders, and treating medical professionals. This is a skilled, multifaceted role, and the appointment of a case manager accordingly needs to have the appropriate qualifications and expertise. We've also found that there are many costs that cannot be put in money terms post-settlement, such as the burden of care on the family, post-traumatic stress, depression, anxiety. And despite millions being paid out, some of my patients have committed suicide, or the parents of the children have committed suicide, leaving the millions still in a trust. The role of the case manager is to help the patient once the case is settled and has no idea how to access the money that is already put aside in the medical certificate in the Road Accident Fund, to actually access those funds, claim from the medical certificate, get the help that they require in terms of doctors, accommodation, and so forth. When the money has been put in trusts traditionally are managed by really good financial people. The patients themselves don't know where to start in trying to find a house or a car, wheelchairs, doctors, rehabilitation specialists, splints. They have no idea where to start, and neither does the trust. The case manager can bridge that gap, where you work with the funders or the trust or the medical certificate in terms of the RAF, and make sure that the actual patient for which millions were put aside actually gets the help that they need. We've put together with the Case Management Association of South Africa and with the assistance of CAMASA, various tiers of case management in postgraduate programs. This would include postgraduate for other bachelor's degrees, where you would go into clinical or medical case management and therefore medical legal case management, or simpler models where you don't necessarily have to have an undergrad degree to begin with, where you'll be non-clinical case managers, so that we can get more case managers out there to manage across the board.
Thank you very much, Alison. The next speaker is Dr. Chris Archer. Dr. Archer is an obstetrician and gynecologist, an expert witness. He's the CEO of the South African Private Practitioners Forum, and he is past chairman of the Gynecology Management Group. Dr. Archer is going to talk to us about the care of cerebral palsy, irrespective of the cause. Chris?
Thank you, Mr. Chairman, and good morning, everybody, and Your Excellency, the President. In 2017, the South African Law Reform Commission requested input into their investigation into medical legal claims. And one of the early questions that they asked was, what single intervention did respondents believe would have the greatest impact on reducing the problems with medical legal claims? Now, we were looking at it specifically from the point of view of cerebral palsy. And what we felt was that at the moment, if harm is done, that harm has to be proved on the basis of common law, where on the basis of the probability, 51%, if that is shown to be causative, then the winner takes all. So 51% actually, in effect, gives the winner 100%. And often the difference between winning and losing in these matters is very subjective, and as often as one has heard, subject to appeal. But what happens to the people who lose? These women, and they're often young, unemployed females, lose their job because they have to look after this child and they have no support. And it just seemed to us that it was an inherently unfair system that awarded the winners with a massive award and the losers got nothing. So our feeling was that we should actually look at trying to replace the current common law system of awarding damages based on the proof of 51%, what is the term? Probability. With a system where all sufferers of cerebral palsy were entitled to compensation. And all that would be required would be for a competent pediatric neurologist to issue a certificate of harm. And then all of these children would be allowed access to a state fund, such as a guardian sort of fund, that would enable them to be provided with sufficient financial resources to meet their requirements on a daily basis until they demise. This does beg the question, of course, is what about the question of damages? And I think we'll go into that a little bit later in the debate that's going to take place after lunch.
Thank you very much. Thank you, Dr. Archer. The final speaker on this broad topic of the care of cerebral palsy children is Dr. Brad Byra. Dr. Byra's qualifications and work experience exceed my capacity to explain them, but he is currently the Managing Director of the Advisory Group. Dr. Byra is going to address us on the continuum of care after settlement or judgment, centres of excellence, which we've been talking about, and particularly funding thereof and case management. Dr. Byra.
Mr. President, honourable ministers and learned colleagues, through the chair and all protocol observed, hello and thank you for being here and thank you for allowing me to speak. I'm going to show you a house view, and that house view is through the chair, a suggestion that the words are a little bit too small. But in doing that, we're talking here about a fundamental human right or a fundamental human dignity, and it's enshrined I'm going to say enshrined very loosely, but at a high level in the Constitution, in the Bill of Rights under sections 10 and section 12, but also in the Children's Act under sections 10 and 11, where it says that we should give consideration to the dignity and access to care, the provision of care, and the provision of social support for any person who has any sort of disability or limitation. If we're giving that consideration, possibly the consideration should be that any person who has cerebral palsy or disabling condition should have a no-fault support to them, Should that occur, then there is no need for litigation in this issue because a person, once diagnosed, moves into a system where care is provisioned through any sort of special purpose vehicle or gardening fund. Were that to occur, a management process for the creation of centres of excellence could look something like the model that I'm going to show you here and that we'll speak about at length. At the bottom is the epidemiology. How many centres of excellence are there? How many are public? How many are private? How many caregivers exist? How much home care and respite care and residential care is currently available? How much do we want to invest in residential care facilities using 10400S standards and global best practices? And off the back of that, what information technology do we have to know what resources we can assimilate and combine? The second piece would then be to say, how do we identify existing centers of excellence? How do we want to establish accreditation and certification forward going for these centers? And we've learned some tremendous lessons out of recent tragedies, but also through SASSA, there are facilities that are well run, well managed, well funded, and well resourced. So there are positive lessons with the negative. We also then want to look at that in terms of how we want the business operating model to look like. How do we create public-private partnerships using supernumerary relationships where private practitioners can have access to state formularies and state resources in a combined funded model? That's one of the challenges that currently we're not managing very well. The second is to say, what kind of models of access to care do we want? How do we bring combined case management together? How do we pre-purchase services like happen in many other social communities in the world where there is national health insurance, but the health insurance providers purchase utilization of beds from public and private states to allow that to happen. The third would be, how do we enroll our academic and social partners to create internships and create learnings? And the fourth level is to then say, if we were to look at the common law and we look at the acts, and bear in mind that we issued in terms of disability more than 1 million grants last month on disability, and we do the same, and that we have a 7.5% prevalence of disability in the country, there is a significant model to change the shift from litigation into social support. Thank you very much.
Thank you very much, Dr. Byron. I just wish to point out, you've heard a number of speakers on the topic of the care of cerebral palsy. Our first debate after lunch, which is to be chaired by Dr. Byron, is on that topic. So more will come in that regard. The next speaker is Dr. and Advocate Anton van der Bout. He is an orthopedic surgeon and a qualified advocate. He is the founder of the South African Medico Legal Society in 2000, which later became the South African Medico Legal Association. Dr. Advocate van der Bout is going to talk to us about the topic of specialized medical courts and medical assessors. Anton?
Thank you, Mr. President, friends and countrymen. I had a dream. That dream started in the 70s when I was studying medicine at Leiden State University in Holland. The dream that the medical fraternity and the legal fraternity could work together at a certain stage. And when I became an orthopedic surgeon, it was clear to me that there was no real cooperation between the medical and the legal fraternity at all. More enmity, more trying to pressurize. So that was the reason why I thought it good to found a foundation like the South African Medical Legal Society at that stage, to bring doctors and lawyers together so that we can get to know each other, to get continued education, and to learn from each other and to take it forward from there. Well, we can see what happens now, 19 years later, where we are now. I think it's a tremendous thing that we achieved by way of the guidance of our judge chairman as well as Herman. I think, however, that we need to go on from here. And there are three things that I think that we should think about, and that are the specialized medical courts. I'm a proponent for that for years already. It's not a new thing in our system. Constitutional court is one of them, labor courts, water court, It's got all kind of advantages, of course. It will unburden the legal system. It will guide the specialized people in a certain direction. You most likely will have a more efficient type of court system. That is the one thing. The other thing is that we should perhaps look at a one expert type of system where you don't have an adversary type of thing for the experts. SAMLA organized under the guidance of Herman course where we did more than 80 hours of training for all members of the Medical Legal Association, not only doctors, but also occupational therapists and psychologists and all the paramedical people, and wrote an exam. And we can say that we, in fact, trained people of our association to be proper medical legal specialists in our own field of expertise. So I would say that if SAMLA is able to make a register of recognized medical legal experts in their own field of expertise, that the court should gradually look at a one expert system for one orthopedic surgeon, one occupational therapist, etc. It's used in other countries as well. It's not a new thing. It's not necessary for me to allude on that. The other thing is what we already know, and it is that the system of assessors has not been used to really the maximum. We know about the assessor system, especially from certain recent, very prominent cases. But to be an assessor on the bench, to help the judge as a medical legal expert, chosen from the register, a trained person who is trained by SAMLA, recognized as an expert. I think the legal system should make use of that as more and more to assist the judge to come to a fair and reasonable judgment. So I would just give that as suggestions that we should think about that, not only improve on things that don't exist yet, but also make use of things that are there already.
Thank you very much, Anton. I can confirm that Anton van der Boot has been talking about these concepts for many years in the board of the South African Medico Legal Association. He has very well-formed ideas in this regard, and he has written in this regard. Our next speaker is Ms. Romany Sutherland. Romany is an attorney and a mediator. She is the Western Cape chairperson and a director of the South African Medico Legal Association. She's going to talk to us about a particular success story that she has experienced, and this is a model for constructive engagement between plaintiff and defendant representatives addressing mental health of healthcare practitioners. Romany.
All right. Good morning, Mr. President, Chair, and colleagues. I have been allotted 2 sessions as I am making representations on behalf of Dr. David Bass, who is the head of the medico-legal unit of the Western Cape Department of Health. Over the past 15 years, the Western Cape Department of Health has experienced a similar escalation of medical malpractice claims as seen in other provinces. This escalation has necessitated the strengthening of professional capacity in the department and a similar reorganization of personnel at the Cape Town office of the State Attorney. At present, case management is handled on behalf of the Western Cape Department of Health by a unit comprising 2 medical practitioners, 2 administrative personnel, and 1 state law advisor, seconded by the Office of the Premier. A specialist medico-legal section has been created in the Cape Town office of the State Attorney and comprises 4 senior attorneys who take instructions from the Western Cape Department of Health. The above claims handling model has been in place for about 2 decades. Having medical practitioners at the center of the model also allows for inter alia, professional scrutiny of evidence in all cases before instructions are provided. The establishment of professional networks which allow for easy identification and engagement of appropriate medical experts. A 24-hour ethical and medico-legal advisory service, and an effective means of feeding lessons learned from litigation back into the Department of Risk Management system. Although the South African Law Reform Commission has been briefed by the National Minister of Health to investigate and draft new legislation to regulate medical malpractice litigation, the time frame for this process is simply unknown, making state health departments with no option but to develop the common law where certain discrete aspects of compensation is concerned. The Western Cape Department of Health is currently focusing on the following strategies on a case-by-case basis. The appointment of joint experts and case managers by consensus in quantum determination. Early, without prejudice settlement of low value or moderate claims by informal negotiation. Pleading for the early establishment of institutional trusts for minors with the inclusion of the top-up and clawback clauses which negate the need for massive upfront payments. Tending of state undertakings in lieu of specific future medical costs where state facilities are considered equivalent to private services, and review of interim payments as standard practice during the course of negotiations. Ultimately, the Western Cape Department of Health Medical Legal Service recognizes that the only effective way to cap the medical malpractice litigation and its financial implications is to reduce preventable clinical error at service level. This, in turn, requires rehabilitation of distressed services and the highest possible level of accountability at all levels of management and clinical oversight throughout each provincial health department. Compared with this priority, all legal strategies which too often occupy center stage effectively amount to damage control and nothing more. That's on behalf of Dr. David Bass. Mr. President, I am an attorney. I specialize in medical negligence law, and I represent the patient and the plaintiff. I have two passions in these cases. The one is keeping medical matters out of courts, and the second is focusing on the mental health of our medical practitioners. I have worked with Dr. Bass for many years, and I can say that this model works. Just lately, I have approached Dr. Bass on the expert opinion panel, as highlighted by Dr. Borat. Immediately, I managed to get an appointment to sit with him and his team, where we discussed how we were going to pilot this project. We proceeded to summarize the medical notes, to highlight the questions of causation that needed to be answered by the expert opinion committee. We then jointly signed the brief, and we jointly signed an agreement that we would both pay for this expert panel. On another matter, I was assisted by Dr. Bass's team in obtaining the hospital records. I then produced an expert report to him and his team, and I said, please, give me an indication as to whether liability in this matter was going to be fought, or whether you could give me an off-the-record or informal concession on liability. That was made, and I was advised to proceed with quantifying the matter. This all happened before the 6 months of the notice of intention to issue legal proceedings was necessary. Dr. Bass allows me to approach him personally. He has a face. He is the decision maker on behalf of the Department of Health. He has settlement authority. I work in all the other provinces, but I do not know of anyone else that is as approachable. I do not know even the identity of any of these other people. My second, very quickly, passion, and something that needs to be addressed, is the burnout, the post-traumatic stress, which is causing our medical students, our nurses and doctors to commit suicide. This is reaching epidemic levels, and it is not being addressed openly in the media. I have a great team of people that we've put together to be addressing this, but we need government endorsement and we need government funding. I urge you, Mr. President, to please consider our plight. Thank you.
Thank you very much. Thank you, Romani. Our next speaker is Professor Alex van der Heever Professor van der Heever is the Chair of Social Security Systems, Administration and Management Studies at the University of the Witwatersrand. Professor van der Heever is well known to departments of health around the country, to the National Treasury, and is very knowledgeable about management, finance and systems. He's going to talk to us about a strategy to address medical negligence claims and road accident claims. Professor van der Heever.
Thank you. Good morning. I'm going to be speaking a bit later, so I'll really just highlight a few issues about what I think would be important in a strategic approach to dealing with both issues. I think that I would break down the problems that one's dealing with in the medico-legal claims framework into a health systems, a health governance issue, a financial management issue, and a legal framework. And in those three areas, you essentially need to implement a holistic framework to properly address what we are seeing. Because in fact, in many instances, the failures that we are experiencing within the system are multifaceted and can't be corrected with siloed approaches to taking the matter forward. So the question really is, how do you institutionalize a coherent institutional framework that can address the full problem that one's dealing with? So if we just start, and I'm just going to give an example on the health systems failure side. If we had to look at what's happening in this, it is, and I've been an expert in a couple of cases, medico-legal cases, and each one of those cases, what stands out is how it would be impossible for that one instance to occur without multiple systems failures. It's not one failure, it's multiple. And therefore, the accountability frameworks that have to be addressed have to actually be more distributed within the system. There's the accountability framework around the hospital, there is around the individual professionals, and there is the overall province itself. So one of the issues, and I'll talk to that, is how to deal with that framework, because it's not going to be addressed with isolated interventions. In respect of both the legal approach going forward and the financial approach going forward, when you look at this kind of problem, it makes sense to actually centralize the administration and management of these issues. So the one thing is to take the financial liability off the provinces and to have it managed outside of them. But that creates a potential mismatch between who is accountable for actually causing the medical negligence and who's paying for it. So you have to institutionalize a connection. And that means that you don't necessarily make the provinces financially liable for the consequences, but you make the individuals and the services and organizations personally accountable for what occurs. That means that you've got to create a link down to what's actually happened at the clinical level. So now institutionalizing that framework is critical. And what I'll also talk to is that I feel that the Office of Health Standards Compliant is not up to the task at the moment of dealing with that. So there has to be a much stronger model introduced to ensure individual accountability. I'll talk to those.
Thank you very much, Professor. We're going to hear more about that after tea. The next speaker is Mr. Gregory Whittaker. He's an actuary, highly experienced expert witness in civil litigation quantum calculations. Gregory is going to talk to us about the State Liability Amendment Bill implications, the issue of structured settlements versus lump sum settlements, and discount rates. Gregory?
Thanks, Mr. President, the Deputy Director of Health and delegates. Just some high-level numbers to start with. Firstly, we've heard the total liability facing the various departments of health, 80.4 billion at the end of 2018, compared to 28 billion only 3 years ago. So the question that needs to be addressed is, well, how come has there been a 52 billion rand increase in the matter of 3 years? I think, well, certainly from the Actuarial Society side, we would welcome the opportunity to unpack this number in more detail, but for that we would need a lot more input from the various departments of health. Just turning to the State Liability Amendment Bill, which seeks to introduce structured settlements as opposed to lump sum payments. On a very broad level, what we've just tried to show in one graph is what does this actually mean through time. So for someone who's, let's say, is going to receive a caregiver 20,000 Rand a month for the rest of their life, and as a 20-year life expectancy, you would generally pay out a lump sum of about 3.6 million Rand. However, if you're going to start paying that out as an installment, one must bear in mind that because you're not reserving, these amounts are undiscounted. So as one moves through time, you could end up in a situation, because as the state, if you take on the longevity risk, you could end up with a claimant who lives beyond their normal life expectancy, paying out a significantly higher sum. So that's just a danger in terms of a structured settlement. To reiterate points that have been made, for example, on the road accident benefit scheme, as Dr. Barrett mentioned, the key thing is to just reduce the accident rate, and similarly, as Professor Becker mentioned, maintenance of equipment and training and those things are imperative. So, when actuaries are calculating liabilities, we always talk about the frequency of claims and then the severity. Generally, we calculate the severities, in other words, the quantum amounts, but we really support efforts to reduce the frequency of claims. Two more points where the actual society would really like to become involved, and is also in life expectancy studies. And then I think something that hasn't been mentioned but it is essential in merits claims is looking at placental pathology to correctly assess merits, because I think a lot of there have been some very interesting studies in that regard, and we can also assist with the statistical interpretation thereof.
Thank you.
That's 2 minutes.
Thank you very much, Greg. Our final speaker in this segment is Mr. Patrick Wysochanski. Patrick works as a manager in terms of managing, organizing, and paying expert witnesses for the state. He's going to talk to us about problematic management of litigation. Patrick?
Good morning, Mr. President. Good morning, Ms. Matsotso. I'm the managing director of a company that appoints expert witnesses and understands the process quite well. A problem exists in the defense of state matters. Some of those problems are the readiness to proceed, therefore postponement, concessions, and this is costly. Also, underskilled defense teams. That includes the experts as well as advocates and counsel. There are easy solutions that have been mentioned today, but I'll run through a quick presentation as to things that we've noticed. A state approach to defending these matters, what we believe. We live in the days of Guptas, tenderpreneurships, and kickbacks. In fact, according to the latest South African corruption report, corruption is widespread in our country, with nearly half of South Africans believing our government officials to be complicit in it, and therefore incapable of stopping it. In this atmosphere of unchecked dishonesty and greed, it's become the norm to steal a little. With no one giving a thought to the consequences of their fraud, as proud South Africans, we understand only too well that when unscrupulous people try to cash in on our public systems through fraudulent claims, the loss could be catastrophic. It could close down hospitals, it could bankrupt departments, it could harm our people and our country, which is why we refuse to turn a blind eye. We build relationships with state clients and arm them with expert testimony from managed network of highly experienced medical professionals. Also that we can uncover the truth, find real justice, and ensure a better, more sustainable future for our nation. What we live by. We swear to protect and save. We promise to empower and enlighten. We vow to be reliable and ethical. We pledge to find truth. We commit to justice because we fight for a better South Africa. concerned South Africans defending South Africa's future. Problems being faced currently: inadequate planning by the state, where plaintiffs are taking a year, 2 years to build up a case. We sometimes get approached a week before a trial to appoint experts. Another problem is unprepared and underskilled counsel. That could easily be fixed by training counsel in terms of the fundamentals of CP and how to address it in court. Other problems faced: payments not being attended to timely. We know that experts that would gladly help the state are saying, sorry, we are owed quite a lot of money. This is a very easy solution to be attended to. Non-reputable experts and case management outfits operating out there. So it's become almost an industry where people are proposedly helping the state, but actually trying to cash in on a fly-by-night situation, make some money quickly. Solution: 7 to 15-day commitment to payments. You lose incredible experts that are willing to help the state, and benchmarking of industry players and experts. Thank you very much.
Thank you, Patrick. And thank you to everybody who spoke this morning. And thank you for helping us to keep to our difficult time constraints. Just before we break this first session, Mr. President, I want to say that if I were to put myself in your shoes and think, how am I going to solve a problem with so many facets and so many expert opinions and so many knowledgeable ways of doing things, it would seem a mammoth and incomprehensible task. That is why we propose at the end of today to have a debate on the establishment of an independent, proper, professional and moral regulatory authority. The end result of today is going to be that the establishment of such an authority could take all of these problems off your mind and out of your hair. Thank you very much. We now break for tea.